Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is what's the harm? The role of uninjured class members in class certification. There has been a series of cases that have considered the role of what have been described as uninjured class members in the certification in antitrust class actions. Now, the basic issue here is, well, wait a second, can we really have a class action if there are people in the class that never suffered any harm? Because at least in theory, they would be collecting damages, and that means maybe that we didn't define the class right or something. But there is quite a bit of controversy, and maybe in principle that's right. But how do you measure it? What are the lines? There is quite a bit of controversy about that. And today we're going to talk with a guest who has thought a lot about this issue, one of the leaders of the plaintiff's class action bar and one of the leading thinkers on this issue. My co-host today is Melissa Maxman. Hi, Melissa.
Hi, John. Thanks for including me.
Melissa, what are we doing today?
So we are addressing an interesting issue that has been much discussed in the antitrust world, in the private class action world for some time now. And that is the issue of what to do about class members who are defined, who are into the class as defined, but have not suffered any actual injury. And this is we've seen this arise in a number of different venues, and there have been some conflicting opinions about it from various courts. So we thought it was a timely issue to raise and discuss, especially as we're moving into a new antitrust era with Jonathan Cantor having been recently confirmed and a new FTC. These private class actions often follow up on investigations brought by the government. And it'll be very interesting to see what happens in this area, which is a follow-up on what the government does in many ways. Katie Benson is one of the leading thinkers and lawyers in this area, and we're delighted to have her. Thank you for coming, Katie.
Thank you, Melissa and John. It's wonderful to be here. I'm looking forward to it.
So starting off, can you explain the seminal case or two that have laid out the four corners of the problem we're talking about?
Sure. Well, I'd start, as I always would, as a plaintiff's class action lawyer, doing private enforcement cases with Rule 23. So where this comes from is Rule 23B3, the predominance inquiry. And what the court is looking at during class certification, when it's considering predominance, is whether the common questions predominate over individualized issues. And in doing so, in particular in an antitrust class certification context, the court is looking to oftentimes a damages methodology that the plaintiffs have put forward with an economist expert that should, in order to certify the class, set forth a reliable methodology to determine class-wide damages. So what we're looking at is the period of time where you're considering class certification. We're not looking at the merits. We're not looking at whether anything went wrong, whether there's liability, and frankly, not even making a final determination as to exactly how much, what those damages, class-wide damages are. There's an initial kind of presentation of it, but the final issue comes at the merit stage. So what the court is looking at this stage under Rule 23 is whether there's this reliable methodology put forward. And oftentimes one of the issues that comes up is, well, defendants will make the argument that there's a certain number of class members or a certain percentage of the class as defined by the plaintiffs that isn't actually injured for any number of different reasons. And oftentimes the plaintiff's expert will say, well, it's no more than 2, 3, 5, 6%. And defense's expert will say, well, it's more, 15, 20, 25, or it's even larger than that beyond. And so the question put to the district court is, what do you do with that information?
So let me stop you and back up for our listeners. Can you explain what type of fact pattern would give rise to a class? Because you think of a class as all people who purchased a widget. How can somebody not be injured if they purchase that widget?
Oftentimes it goes to how they went about making the purchase. So whether they purchase through other intermediaries, that is oftentimes how it can happen. Other times it can go to perhaps when they purchased within the particular class period. So depending on when the purchase happens, if you have a lengthy class period, it can also go to the question of, I think, for example, in the context of a pharmaceutical case where a class member is purchasing, for example, a brand versus a generic. And so the question of whether that particular class member is injured and to what extent then afterwards they're injured would depend on exactly what type of product they're purchasing during the class period. I don't know, John, if you have other thoughts or examples of when that can
Katie,
arise.
what I was thinking about was maybe this. I don't know if this is helpful, but picture yourself drawing a circle and saying, hey, the class is everybody who's inside that circle, right? Drawing that circle is a difficult task. And it may end up being that some of the edges are shaded with uninjured class people, but it may also be that it's not really a circle you're drawing, but some other kind of shape. So the methodology is designed to get a perfect circle. In other words, only people who have been injured, but nobody who has been uninjured in the circle, and nobody who has been injured outside of the circle, and figuring out how exactly to draw that circle, or whether it really is a perfect circle is the challenge. And I think where the rubber hits the road, I think, is trying to figure out, well, how imperfect can that circle be? Right.
Well, you saying it has to be a perfect circle makes me, as the plaintiff's lawyer, nervous because it doesn't, under, at least, from my point of view, and a lot of the case law says it doesn't have to be a perfect circle, where there's going to be some gray area around the margins. And you're right. The question that's being put to the courts, I think more and more recently, is how much of a gray area, and relatedly, how much does the court have to decide that gray area at class certification?
I think that's right, Kate. I think 100% right. And I don't mean to suggest that you can draw a perfect circle, because I think it's very hard. I think ideally, okay, if with perfect information, you could draw the perfect circle. But you're right. I mean, there is going to be flexibility. And the question is how much flexibility? Because you could imagine a class where you get it 90% wrong, and there still could be a lot of uninjured people in there. You could also imagine a class where you get it 99% right, and there would be a lot of uninjured people or injured people who are outside of the circle. So dealing with this issue of injury, I think sometimes people kind of boil it down to, well, what percentage are you coming up with that's uninjured? I think that's kind of an imperfect test.
Yeah, I mean, it is. And when we see the numbers, I mean, as I mentioned before, sometimes during the battle of the experts at class certification, you're going to have plaintiffs' experts say, well, the uninjured portion is going to be no more than some relatively small percentage. And oftentimes you hear from defense experts that no, it's going to be a larger percentage. And those numbers range. There's cases that say, and again, we're talking about the term that often is thrown around, de minimis. It shouldn't be more than de minimis. And so what is de minimis? And what you see courts doing, I think more and more, is trying to assign a figure to the concept of de minimis. And we saw that somewhat recently with the Bumblebee decision in the Ninth Circuit, which was then vacated. It's on review en banc. They didn't come out with a number, but the court there seemed to suggest that something in the 10 to 12% range was perhaps not de minimis, but again, didn't kind of commit to a figure.
Yeah, I've seen cases, 5% was a range. I think, maybe a little bit higher. I think that's right. I think maybe when you get into the teens, courts start to get a little bit uncomfortable. But then there's the other issue that comes up, which is, and it came up in the Bumblebee decision. You read, full disclosure, I have a client involved in that case, although my clients are not involved in the appeal, and they have settlements that are pending. The issue, the issue is there. How does that methodology work out? And what if the two experts disagree? How do you figure that out at class cert?
Right. And so what the Ninth Circuit's decision, which again was vacated and is going to be considered en banc, but what the Ninth Circuit said there was that the district court. I'll take a step back. In Bumblebee, the district court had a plaintiff's expert saying it was a relatively small figure. I think it was around 5 or 6% that might be uninjured in the class. And the defense expert said, well, it's 28% of the class. And so that's a really wide delta there. And the district court did its rigorous analysis at class certification, certified the class. The question of which expert was right was not something that the district court took on and shouldn't have taken on based on the controlling authority. What the Ninth Circuit in its original decision earlier this year in Bumblebee said was the court needs to do more and needs to start making findings as to whether the plaintiff's expert is right or whether the defense expert is right. Because and the district court here hadn't done that, was required to under the predominance prong of class certification. And so needed to do it now. That is a departure in certainly in my view and in the plaintiff's bar view, but I think folks recognize it generally that it is a departure from what the authority was to date. And I would say, is really having the district court step into the shoes of something that really is traditionally in the province of the jury to be making that determination as to which expert is right at trial.
It gets very, very messy very quickly. And I think the other case we might want to commend our listeners to is the rail freight case in the DC circuit from a few years ago, which I think was probably one of the first to really wrestle with these issues and has, I think now courts around the country are trying to figure out what to do.
Right. There's also the Asakal decision out of the First Circuit from a few years ago, which is one that the Ninth was looking to when it was considering this question of uninjured class members and what percentage is appropriate. So as we think about what this means at class certification, we're focused here on antitrust. It has it certainly has an impact on antitrust. These are antitrust cases. I think oftentimes we see cases that are moving Rule 23 case law or moving the rule in a particular direction come in the antitrust context. I'm not surprised by that. I think you folks wouldn't be either. But it also then becomes a question of, maybe you can figure out, maybe there is a percentage that makes sense for purposes of an antitrust case or a securities case. It can be relatively easily, or I don't want to say easily, but it's something that can be addressed by the experts at class cert. The question is, what does this mean for a lot of other areas of the law and certifying a class, and what is an uninjured class member? And oftentimes it's going to be more challenging to figure that out in in other class cases that are not antitrust.
Yeah, I was going to say we're very comfortable with approximations in antitrust class actions in particular. But in antitrust generally, what is a rule of thumb for monopoly market share, for example? I mean, just by analogy. I'm wondering what makes judges, or at least this Ninth Circuit decision in Bumblebee, less comfortable with that gray area, with that uncertainty at the class certification stage when we really haven't had full discovery.
Well, yeah, and I think part of the answer might be that by the way the case law is going, by the time you get to class certification, you often do have pretty fulsome discovery. It's happening later and later in the process.
Yeah.
I think what troubles courts is the idea that somebody would get paid who shouldn't get paid. It's, you hear about citations to the Rules Enabling Act, and expanding rights beyond what other. I think at its core that's what this issue touches upon, and there's something to that. If the methodology is so imprecise that you're getting a lot of people who shouldn't be in the class, it dilutes the value, it dilutes the payments that should be made to the people who are actually injured. So I think there is a policy consideration making sure that, again, Katie, I take your point. Drawing the perfect circle is probably too demanding, but you want to draw a circle that's more or less right?
Right. No, I agree with that. I think where the way that I think about it is, at class certification, we're looking at a methodology and we want to ensure that methodology is reliable. And district courts do their rigorous analysis. And that is an approach and has been the law. And that's the law that we're prepared to contend with. What we see more and more, and what this Bumblebee decision from the plaintiff side, gives me concern, is the concept of now we're starting to adjudicate. We're starting to make decisions about who's right and who's wrong at class certification. And if the plaintiff's methodology is reliable and it meets the standards of Rule 23, and the court has looked at it rigorously to determine that is the case, then that's what you put to the jury. And to your point, John, it's true. You actually end up with class certification happening not all that far away from when it ultimately gets put to the jury in some of these cases, precisely because the standards of class certification are so rigorous in an antitrust case. You really have to have gathered, your discovery in order to put this forward. But ultimately, at the end of the day, if the jury is making the decision between is the plaintiff's expert right? Is it's 5-6%, and that's okay, and we'll figure out what to do with that percentage, or defense experts, right? To me, that doesn't mean that a class doesn't get certified, because there's a lot of other common questions that predominate and reasons to certify the class that simply the jury picking the defense side or siding with the defense expert or siding with the plaintiff's expert at trial is how we want to ultimately decide it. Whether it's prepared to go to trial as a class case is really the only question that the district court should properly be considering.
Although, again, I think that the class certification requirements have expanded. It's the reason we're doing it later. That's the reason we're doing it with more discovery. And I think that there is some case law out there that suggests that judges should be making a call on which, on which expert is, if there's a battle of the expert in class certification, I think there's some authority that suggests that the judge should be making a call on which expert wins.
Well, it's out there, and I'll say some judges think that they should be making that call. And then it gives rise to the question, and we've talked about this before in other contexts, of what does that mean for the district court's consideration at class certification? And we're seeing more evidentiary hearings as a result. So judges are less, if they're going to be, or they think they need to really, hear from these experts, then they call them in and they put them on the stand and they have them testify, whether it's, through direct and cross-examination or in one of these, the term hot tub, I think we like to call it an expert roundtable, where the experts are really, the battle actually happens, and it happens in open court, and the judge is very engaged in questioning. And so we're seeing more and more of those, perhaps coming from, the judge's understanding that they need to be looking at this, even if ultimately they're not going to make the ultimate decision between which, who wins at that stage.
Yeah. And I mean, Katie, it's an interesting question because class certification, like many things in antitrust, has become much, much more complicated, more expensive. I don't want to date myself, but I remember times when, you could basically get away with putting in an affidavit from somebody that just said, yeah, I think there's a class might be here. And a lot of judges would do that. There's some rules that are still on the books. I think in some local rules, in some courts that say, if you have a class, if you're alleging a class, you must certify that class within 90 days. 90 days. Okay. In antitrust cases, I don't know your experience, but it is often years before you get to a class certification hearing.
Absolutely.
Not 90 days.
I've heard from some of my colleagues that apparently it wasn't unusual to stipulate to class certification. Maybe not always in the antitrust context, but that wasn't unusual. I would say back in the day, but you're right. Today, no way, no how.
I want to go back to these experts and what a judge does with the experts, because that to me is an area of huge importance. If I'm a judge and I hear two equally credible experts to my ears, cross-examined by the other side, and there are flaws with both analyses, but there are merits with both analyses, I'm going to kind of say, well, defendants say 28%, plaintiffs say 4%. I don't know yet. I haven't heard all the evidence yet. Let's split the baby. What's the difference, halfway between? Or I'm going to let it go because it seems like there's enough here to certify a class. And class actions are by their very nature rough approximations. There's the fiction of the class representative that all facts are identical with every class member to those of the lead class representative. There's the fiction that, even Rule 23 itself defines things in preponderance, or they don't say every single last one. And I guess what I'm struggling with is the Ninth Circuit panel opinion in Bumblebee. Obviously, I understand why they came up with that, because it gives some sort of veneer of certainty. But as a plaintiff's lawyer, help me figure out what would be the proper approach.
I think the proper approach is for the court to evaluate the plaintiff's damages methodology and ensure that it's reliable, and that as plaintiff is putting forward, envisioning what the case is going to look like as a certified class at trial. And we don't require that, to your point, Melissa, all class members are identical to the class representative.
Right.
We think about it in a broader sense of, as goes the class rep, so goes the class. So if the class rep is going to put on evidence and demonstrate liability, and then the same is going to be true for the class as a whole. And it's an efficient mechanism of adjudicating these questions. The private enforcement of the antitrust laws, is a significant part of ensuring that we don't have antitrust violations going on. So I see them as kind of, it's an important part of the process, an important part of the puzzle.
I agree.
And
I
so
agree.
to defeat government officials, go ahead.
Many government officials would heartily agree. I've heard government officials say over and over again, well, the private bar will take care of it.
Right. So. And so, I can understand a reluctance if plaintiff is coming forward with a class, in a hypothetical where plaintiff's expert is saying, even based on my analysis and my methodology as I'm putting forward, we're going to end up with, a significant portion of the class that is uninjured. Well, I think, yes, I can see how that's problematic because what that means is that, plaintiffs haven't defined the class and that circle carefully. And that's a difficult process. Having done that and having thought about how to articulate it and what's in and what's out and why it makes sense to include certain categories and not others, and what that means for your damages methodology. So that I can understand. I think the challenge comes where, the purpose of our civil litigation process is really to have the parties putting forth their best arguments and presenting them and then having those issues decided. We want these issues to be adjudicated and decided. And so what I see oftentimes and with uninjured class members or, what's the percentage? And maybe now it's ticked over one additional percentage and now it's too many as opposed to, is that you're not getting, you're not getting these issues adjudicated. You're not getting these issues decided. And really what you're doing is ensuring that nothing, the merits are never reached on these issues. And that's why a bright line rule is, problematic because what it means is that this is okay. And then we have an additional percentage or a 0.5%. And all of a sudden it's not okay. And we're not comfortable with it, which is why Rule 23 doesn't have that line and why a lot of the courts have really tried to be open and not set those bright lines of percentages. Because ultimately it's the court's discretion in terms of thinking about how this is going to work as a class action.
Although, with bright lines, you get consistency, and with discretion, sometimes the draw of the judge would make a difference in how cases would come out. Katie, let me put this provocative question to you. I think there are people in the defense bar who believe that as the perspective of a plaintiff's lawyer is, let me draw that circle as large as I can conceivably do it. Because the bigger the circle, the more dollars, and the more dollars, the higher my fees. Talk to me about that. How did the plaintiffs? Is there any merit to that? How do plaintiffs approach trying to draw this circle?
Yeah, it's look. I would say first of all that's it's not my experience. It is an incredible challenge to define a class and put forth a methodology that is going to, reliably estimate damages for the class that you've defined. And I think, frankly, the what I see actually happening is we're not talking about, well, we have this huge class with huge percentages of it that are potentially uninjured. What you ultimately see is it really is the margins. Those are the things that are getting litigated. Well, is this particular group, because of how they operate, are they in or are they out? And sure, a plaintiff's lawyer might make the decision that they're in and have reasons to argue and assert that this is an injured class member and here's how they've been injured and get recovery for them. But I would say the best response to it is I don't see a lot of class certification orders coming out saying, 90% of this class is uninjured as defined. What you end up seeing is that there's these little pieces around the edges, and those are judgment calls. And those are things that, plaintiffs are thinking about when they're defining a class. Sometimes you get some feedback from a court. It's become not uncommon to move for class cert twice. A first shot and then a second shot to, after getting guidance from the court and seeing some feedback. So I think that really we see it along the margins, and there's certainly reasonable arguments in both directions as to why certain groups would be in or out, but that's where you see it happening, not kind of in broad swaths of the class.
And the closer you get to precision, the more expensive it gets to get there. And as we add greater demands on precision, it costs more and more to get to class certification. So I think it's a very challenging issue, because I think we would all agree we really don't want to pay people who weren't hurt. I mean, that's not what anybody's trying to do. And likewise, we don't want to exclude people who are. But the trying to figure out where the lines are is an issue that's going to be with us for some time.
Right. No, I think that's true. And then also, not just where the lines are, but when is the decision about what the right answer is made? And so I'm curious to see what the Ninth Circuit en banc does with this idea that, put forth by the original 3-judge panel, or the 2 judges in the majority, that this is a decision that the district court really needs to be making at class certification. And so we'll see what the en banc, what the full court says about that.
And I think that and there and in many other cases, I think this is one of the issues that will be vexing us, and stay tuned. And as folks may know, this is a U.S. issue, but so many countries outside the United States are trying to build their own system of class action or mass action or common collection. And these issues are going to vex them too. So stay tuned. Fascinating issue. Katie, let's shift gears a little, if it's okay. And let me ask you, what advice do you have for a young lawyer that's interested in doing what you do?
Yeah, absolutely. I think one of the most challenging and scary things about antitrust is it's a really complicated area of the law. And there's a lot of the economic aspect and analysis that can be daunting to young lawyers, and especially daunting to those who don't have, who weren't economics majors in college and haven't thought about these issues previously, or didn't take antitrust law in law school. So what I would say is, don't be afraid to jump into it, to get involved, to learn these issues, because they are accessible. They're incredibly fun and challenging to learn about, but you don't have to be an economist in order to be able to practice antitrust law. And that's something that I needed to get over when I first started practicing antitrust. And I see it with some other, junior lawyers that I work with at our firm. So we're always trying to bring people in who express an interest, but say, I don't know, up or down from anything from an economics perspective. And that's not a reason not to try and to get involved.
And there are resources out there, right? If people are nervous, there are resources out there. I mean, the antitrust law section is one of them. Well, so let me give you the next question to ask, which think of a question that's really, really hard for Katie to answer.
Tell us something interesting about yourself that we don't know if we only know you as an antitrust lawyer.
I'll say this. I am an avid cyclist and really enjoy not only cycling, doing rides on the weekend, but also a huge fan of the Tour de France every year, and have been for most of my life. That was something that was passed down from my parents, and I enjoy it immensely. It's a sport that I think a lot of Americans don't know a lot about. But my parents were always avid cyclists and cycling fans. And so, it's something that I watch every summer. It's very exciting. I get up very early to watch them climb the Alps. It's wonderful.
Do you think there would be greater interest in the Tour de France if they had a unicycle division?
There's a lot of strategy in the Tour. I mean, it looks like it's just a bunch of cyclists riding together. There's an incredible amount of strategy. And, admittedly, I did get mostly into it at the beginning because I was a very big Lance Armstrong fan. I understand he's a complicated figure.
I was going to for Lance or anti-Lance.
Yeah. Complicated was a very big Lance Armstrong fan back in the day. But there's a lot of strategy. There's a lot of planning and strategy and teamwork that goes into a cycling race. And that's a really cool, I think, kind of additional piece of it. It's not just watching people ride through the beautiful French countryside. So,
for the record, she did not take the bait on the unicycle question. Let's go to our final segment we call the Curious Hat.
And now it's time for the Curious Hat.
Katie, in my right hand, I have a series of questions that are numbered 1 to 25. If we were together, I'd have them in a hat and you would pull them out. But since we are not together, I'm going to ask you to choose a number between 1 and 25. I will read you that question that corresponds with the number you choose.
12.
Okay. So that's an interesting strategy. A lot of people go with 12 because they think if they stick with something that's right in the middle, it won't be a hard question. But I've been doing this for a while, by the way. All right. So here's the question. What is your favorite thing to cook?
That's a good question. I feel like I've expanded my repertoire. There's so much more I know how to cook now, thanks to the pandemic and being home more often. So, I would say pasta of any kind. I really enjoy kind of a simple Italian pasta, cooked the right amount, not overcooked pasta. And it's something that my husband really enjoys too. So, depending on the season, not a particular type, but depending on the season, that's a favorite. If it was summer, I'd say something with zucchini, very light and fresh. And if it's winter, something with one of those really, heavy red sauces, but that's a favorite.
Would you consider mac and cheese to be part of that general genre?
Oh, absolutely. Absolutely. Especially if you add something like, frozen peas or something to it. So then it's really elevated. Absolutely.
Would you ever cook with a powdered cheese in the mac and cheese?
Yes. Oh, Annie's. Who doesn't love Annie's mac and cheese, right?
Who doesn't?
It's a staple. It's a staple in the house. That's if you want the answer to be mac and cheese, that's fine with me. I'm on board.
All right. Well, I got the answer I wanted, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.